And you represent?
A number of the intervener plaintiffs involving probation officers, firefighters, and others, and David Fox and Fox and Fox. I just want to debrief you on two things about Judge Hurd's decision, which was May 25 of 2012. One, he made it clear that if COLA can be overturned, so can the base pension. So we're not just talking about COLA here. The implication of this is that anybody in the public sector receiving a pension, including a COLA and including a fixed amount, can have it changed. That's the theory. It's a far-reaching theory. Just want to make that point. And that's clear in the opinion, of course, is in the transcript.
I think we understand that point. Go ahead.
He also made it clear, and he said, he didn't get to this, but there are strong arguments on the COLA, an issue that he never got to. And I'll be within my 5 minutes, Your Honor. In terms of some of my plaintiffs, the ones we represent, we even had an issue involving the plain meaning of what something says. We lost. We wanted to go outside the plain meaning of something, and there was a decision that said you can't do that. And so we learned the hard way of appealing that, but if nobody says anything to the appellate division, I think the chances of prevailing against the plain language in that situation are not strong. And we actually have, the best arguments I don't have to make because the Attorney General and the Office of Legislative Services have already made them. And I hesitate to take your time up by quoting.
You don't have to because
You read them.
I read them again.
All right, I know, but I just want to make that point. I don't think it's been emphasized yet that our arguments are already corroborated by an Attorney General's argument and an OLS argument. And the only reason that we have that we should not follow those arguments, no matter how specific they are, is they don't specifically refer to the COLA. And the other argument is that the benefits doesn't statute, that you can't impair them, is that they don't specifically refer to the COLA. I mean, the arguments of the Attorney General as a result are a stretch. And I think it's because of the Attorney General now, not the Attorney General a few years ago. So all we're saying is the arguments are a stretch. They say the COLA termination is only temporary. Well, it's 2 years and it takes committees and it could be 10 years, not that it matters. And there are other arguments that are simply just like that. Now, on the contract issue, I think, I don't want to beat it anymore, Your Honor. I just have one or two more comments. We know what U.S. Trust says about contracts. I don't think there's any question here, even Judge Hurd in May 25th of 12 seems to say this is, if you want to talk about contracts, you've got strong arguments. So we have, in addition,
I think we understand your argument.
one more point, just one more.
What I'm hearing is repetition here.
I'm trying not to do that. May I make one more point?
No, I think I'm going to ask you.
Okay, thank you.
And it's not because your arguments aren't good, but
Okay,
they've been thoroughly briefed. And we do really need to hear from the respondent as well.